Good
Ms.
afternoon,
Davis.
Chairman Pierce and members Hirazawa, Ms. Gamera, Schiffer, and Johnson. And once again, thank you for allowing me to appear before you and to speak on these most important issues. My name is Doreen Davis. As you heard yesterday, I'm a partner at Jones Day, and I'm here representing the Retail Industry Leaders Association, and I'm accompanied today, as I was yesterday, by Kelly Kolb from RELA. I want to first address my supposition, which is that, contrary to what some of the other speakers have said, I believe that requiring email addresses and phone numbers is in fact a bigger invasion of privacy than requiring the provision of home addresses. And the reason is that if you get a visitor at your home who's unwanted, you don't have to open the door, or you can shut the door in that person's face, and you can be done. You don't have to speak to that person at all. You don't have to deal with any message coming from that person. An email address, if someone has your email address, you can't turn off your inbox. You do have the ability, of course, to mark something as spam or to block a particular sender. But in today's world, if these email addresses are given, they're being provided to the union, they're going to also be provided to the union organizing committee. And emails can be sent incoming to employees from many different addresses. You could have a different person sending an email every day, so that you couldn't effectively block the emails coming into your inbox. Similarly with your cell phone. You all know, I don't know about you, but I'm getting more and more spam type phone calls on my cell phone. And even though you try to block one number, a different number comes up and you can't block them. So you don't really have the ability either in your email inbox or in your cell phone to just say no very easily like you do at your home where you can shut your door. With regard to the restriction on the use of the Excelsior list, I think that that would be a good start. I have personal experience in the last 2 years, a case in the New Orleans region. It was a decertification election, and I talked about this in the comments, where the petitioner for the decert election was sent pornography to his home address repeatedly by the union. It was actually substantiated in an email among the union organizers that they were going to do this to this guy because he filed the petition. Of course, we got an election set aside. We got a rerun. But if that can happen now under the rules, I think at a minimum, if the board's going to consider requiring employees to turn over email addresses and phone numbers, they have to allow the employers to seek the consent of the employee before that information is turned over. And I suggest to you that with the 2-day time limit of having to turn around the Excelsior list, practically I don't know how that would work. I don't think there's enough time in the 2 days to go out to employees and get their express consent to turn over that information. So I think you'd have to look at that time period as well. Data breach issues are of extreme importance to my clients in the retail industry. You've read too much about that. So that is a particular concern of theirs in the event that they would be required to turn over personal email addresses that they had of any employees. I don't know about all of you, but I use my personal email address for banking, too much online shopping according to my husband, and for many other personal reasons. I use my personal email address. So turning those over makes it very susceptible to someone with an evil motive, and certainly not all union campaigns or union organizers have evil motives, but could very easily lead to a breach of an employee's personal data. And in the situation where the employer does not have personal email addresses, but does have company email addresses, by requiring the employer to turn over the company email addresses, you are, of course, automatically requiring that the employer give access to the union to their email system, which, of course, under current law is not the state of the law. Could be changed in the future, but as of right now, employers are not required to allow union access to their company email systems. But under this proposed rule, that's the upshot of what would happen. And then I just have an additional concern about the shift and location being required on the Excelsior list. And again, this is particular to retail employers. Employees often get a change in shift or a change in department on the retail selling floor. You know, one day they could be in one place and one day they could be another, or they could be covering more than one area, and they can also be changing shifts. What's going to happen is at what point, if the employer does not constantly update that list with the change in the shift or the department, does it put them at risk for having the election being overturned because the Excelsior list is not accurate? I think that's a practical problem, at least in the retail industry, with the requirement of the shift and the location. So, thank you.
Thank you.
I just have one question about, in the retail industry, if there are questions regarding scope of unit, are there instances, and I don't know, where people may actually be in the unit on some days and outside of the unit on other days because of position interchange?
Absolutely. Happens frequently in retail.
Thank you.
Well, that wasn't exactly a voter list question, but
Right.
thanks for your answer.